lasting power of attorney, also referred to as an LPA, is a legal document that lets you, known as the donor, appoint one or more people, known as the attorneys, to help you make decisions or to make decisions on your behalf. This gives you more control over what happens to you if you have an accident or an illness and cannot make your own decisions. You must be over 18 and have mental capacity when you first make your LPA. There are two types of LPA: a health and welfare and property and financial affairs. You can choose to make one or both. Firstly, you will need to choose your attorney. You can have more than one. You can also nominate other people to replace your attorney or attorneys if at some point they cannot act on your behalf anymore. The forms need to be completed, which appoints the people as attorneys, and then you are to have all parties named within the document sign and be witnessed. Lastly, you will need to register your LPA with the Office of the Public Guardian. This can take up to 10 weeks. It costs £82 to register an LPA unless you qualify for a reduction or exemption. You can cancel your LPA if you no longer need it or wish to make a new one. A health and welfare LPA gives an attorney the power to make decisions about things such as your daily routine, for example, washing, dressing and eating, for medical care, moving into a care home, and the right to make decisions over life-sustaining treatment. It can only be used when you are unable to make your own decisions. A lasting power of attorney for property and financial affairs allows the attorney to make decisions about money and property for you. For example, managing a bank account or build society account, paying bills, collecting benefits or a pension, or perhaps even selling your home. It can be used as soon as it's registered with your permission. Your attorney needs to be 18 or over. They could be a friend, relative, a professional, or your husband, wife, or partner. You must appoint someone who has the mental capacity to make their own decisions. When choosing an attorney, it's important to think about how well they look after their own affairs, for example, their finances. How well you know them, whether you trust them to make decisions in your best interests, and how happy they will be to make decisions for you. With this in mind, you may wish to find out more about an attorney's responsibilities to help with your decision. You cannot choose someone who is subject to a debt relief order or is bankrupt if you're making a lasting power of attorney for property and financial affairs. If you're appointing more than one person, you must decide if they'll make decisions firstly, separately or together, or alternatively, just together. If you choose separately or together, sometimes called jointly and severally, this means attorneys can make decisions on their own or with other attorneys. Alternatively, if you wish for your attorneys to act together, sometimes called jointly, this means all attorneys must agree on the decision. You can also choose to let them make some decisions jointly and others jointly and severally. Attorneys who are appointed jointly must all agree or they cannot make the decision. If you would like to speak with an advisor, please contact your local Ellis Bates office and we will put you in contact with one of our specialist advisors.